I have a great pleasure in welcoming you all to this session. This is actually in continuation of our earlier session on the insight into the issue of the private placement and the preferential basis. Because last time when we conducted the session, we could not complete the session. That is why we decided we'll have it part 2. And we have Mr. Ranganathan, who was actually there present earlier. You are all aware, Mr. Ranganathan, but still it is my duty to introduce Mr. Ranganathan formally. Ranganathan, I know him over more than 3 decades, maybe in mid-95 onwards. I used to see him in Navi Mumbai. When I used to go regularly to CCGRT, he was actually at that time looking after the Navi Mumbai chapter. And he used to be very, very participative in all the webinars and programs, etc., and other things and all. And he has been actually with Edelweiss Financial Services and the Tata Group earlier. And he is our fellow member of our institute and also a fellow member of the Cost and Management Accountants Institute and also a qualified lawyer. He got almost about 33 years of the experience. Now he is in the practice in various areas like investment banking, company law, corporate restructuring, NBSC, ARC, and allied matters. And besides, he was also a member of the Secretarial Standard Board of our institute. And he was also a member of the Company Law Review Committee, which was constituted by Ministry of Corporate Affairs to review the Companies Act 2013. And besides, he has been addressing the various webinars and he is delivering the lectures in the various business schools and professional institutions. And he has been conducting sessions for our practicing people as well. And in addition to that, he has been presenting the various papers, not only in nationally, but also in internationally. Such a well-known person, Ranganathan. I have a great pleasure in welcoming you to Ranganathan. And then our presenter today our presenter is actually Khadija from Mehta. And you all know her. I don't have to give an introduction. The rest of the people I'm not going to introduce. Today, Dipti is preoccupied. She is not able to make it today. So she is not going to be there. But of course, we have our Mr. Sudhakar, who's, our expert. You all know him. You all heard him in many forums. He also doesn't need any introduction at all. And with these two experts on our panel, definitely we will delve into the second part of the private placement of the preferential issues. With this, I request Mr. Sudhakar to say a few words. Although we introduced the subject earlier, but still, I'll ask him to share his expert thoughts and then Ranganathan would say something. Then we'll move forward. Over to Sudhakar, please.
No, I think, Bala, in all humility, let me say that Ranga is the right person to say the initial intro talk than of me. So, Ranga, please take the initiative.
Okay. Good morning, everyone. Good morning, Bala sir, Sudhakar, Khatija, and Mehta.
Ranga, so the light behind you is coming on your face.
Yeah, okay? No. This
Perfect.
is okay.
Perfect.
Sorry. Thank you. So that is what we need. Some mentors, right? Thank you. Thank you, Sudhakar. So good morning, everyone. And thanks to Mehta and Mehta again for inviting me to continue what we left our journey in the last, maybe on 8th, I believe, on 8th of this month. So thanks once again to be. Just to recapitulate and just wanted to reiterate one very clear thing, all of you friends, is that, please understand, I would keep on reiterating because even after these sessions also some people, I don't know whether they attended or not, again, the difference between private placement and preferential offer or issue. So let me put it in a very small, in a nutshell, saying a private placement is a broad umbrella within which a preferential offer also comes. The difference is preferential offer or issue, whatever you call, is only for equities and convertible instruments. Simple. Whereas in a private placement, you can extend this to even the debt securities or any other securities which are in the form of debt or which are not in the form of an equity. That's a simple substance of private placement and preferential offer, right? So it's like an independent director forming a subset of non-executive directors. It's as simple as that, friends. If you understand that, then please, 62, every time this question also comes, should I refer to 42? Should I? Yes, you have to refer to 42. Section 63 and 42 have to go because 42 lays down the process, and 62 gives you the enabling is the charging section and enabling you to go ahead with the issue. So that's the first thing which I just wanted to emphasize once again. Second very important factor which I again want to emphasize is that please ensure that before you do any preferential offer, ensure that your articles of association contains a provision to do a preferential offer. Please, we all forget to do this, and when it comes to the last moment, when we do this, when we go for again to change the articles, a lot of hue and cry happens and it doesn't augur well. So please, friends, these are the two very important things. Later on, I will also take you through one of the very important aspect of articles of association with respect to preferential offer in case of a listed entity. We will straight away questions have come. What is the process to convert equity share warrants into on receipt of full payments? Straight away answer कर दूं या बाद में करेंगे छोड़ो.
Thank you very much, Ranganathan. One thing
I would request that Anand Jain or somebody to give an answer also to this. It's as simple as he should provide the answer immediately to this on the chat box. Chalo, go ahead, Bala sir.
Ranganathan, thank you very much. Really speaking, you touched upon the very, very valid point. In fact, I would like to inform to you and as well as to the audience also, when we actually started the masterclass of this company law, the very first chapter we actually got into is definitions. Because Mr. Sudhakar, I remember that time also, Sudhakar very clearly said that particular time, we will have to go through the definition section, we have to understand the concept, and the interpretation is very, very important. The point just now you touched upon is very, very clearly spelled out. It is only relating to definition section of the securities. That's all. Once you understand how the securities are actually defined, then coming to private placement or preferential issue and other thing and all, you will not make any mistake at all. That is the crux of the point. Most of our people, we don't refer the definition section at all. We straight away get into the provisions. That is where the problem actually comes into. I think we need to understand the definition and we'll have to interpret it correctly. That is my submission. Over to Sudhakar, please.
Yeah. Thank you, Bala, and good morning, everyone. And in fact, last week I was traveling to Bangalore and Kolkata, met about 100 and odd professionals at different ages, got an opportunity to address most of them. In fact, while I was doing that, I told those professionals, as well as I'm telling to all the participants today, is also the way the professional dynamics are getting changed with the kind of amendments, with the kind of complexities, ambiguities, what we have to deal with. A lot of professional challenges are there. Several times I said this, with every challenge, there is a hidden opportunity is there. So I told those professionals, and I'm telling you also, is that on one side, I envy them, and one side, I pity them also. I envy them because the way the dynamics of the profession is there, the amount of challenges are there, the amount of opportunities are there. Despite the fact, had we been 20 years younger, we would have got the opportunity to meet these challenges and to get these opportunities. Having said that, at the same point of time, sometimes I really pity them also, and I thank my God, okay, we would hang our boots from this active side of the profession. The reason being, every day morning, the moment you open your mailbox, 3-4 amendments are there. By the time you understand, by the time you are able to digest it, another 3-4 are pouring on your head. So, but only the blessing in disguise is a lot of opportunities are there, and to meet those opportunities, to meet the challenges, several professionals or professional institutes are organizing these kind of webinars. Several professionals are coming with their newsletters also. So a lot of guidance is there. It is up to us how much we are able to eat and how much we are able to digest that. In fact, some of them definitely they are praising our webinars, the kind of topics, the kind of speakers whom we are bringing. In fact, for last week's private placement, I have been told that, sir, you are going to have your preferential issue also. And you are bringing the kind of panelist is the person with in-depth knowledge of that. So Ranga got a lot of appreciation for before the last week to last week, this thing. And they have a lot of expectations, Ranga, from you for this webinar also. And I'm sure that you will meet their expectations. Several participants are there whom I already met in that particular last week. And so I also make a request. I requested, of course, several of them, and I'm making a request to the participants also. If any of you, I'm sure that you are having an in-depth knowledge and expertise in different fields, kindly write to us that you volunteer to be a panelist, because some of you, I may not be knowing you also, or we may not be knowing you, but you want to be a panelist on our webinars. So kindly write to us. This is your area of expertise and this is where you want to join us as a panelist. Share your thoughts, share your experiences so that we could get benefited mutually. Finally, I would like to announce that Deepti is not there today, but next week we are slightly deviating from the masterclass on issue of securities for some reasons. And Mr. Bala will be taking this and he will be going to deal with all the ROC adjudication proceedings and etc. We'll be having a wonderful program. And unfortunately, I will not be able to join that next week's program. So with this, I request Khadija to take it further.
Yeah. Thank you, Sudhakar sir. One second. Thank you, Sudhakar sir, for that, what do you call, giving a brief. But I would also want to put a disclaimer. I'm not a Virendra Sehwag to face and hit the first ball for a six. I'm a Rahul Dravid mode, so I will live up to the expectation. So, so I'll play to the deliveries. Okay, that's
Great,
okay.
Great.
Thanks, Sudhakar. Thanks a lot. Yeah, over to you, Khadija.
Yeah. Thank you, sir.
Go to the PowerPoint. Yeah. Okay. Go ahead, please.
So
So
the
the
way,
last
Khadija, 1 minute, the way we are having sequels to the movies these days, Bhool Bhulaiya and Pushpa and all. So we are having a sequel to our last week's webinar also. This is part 2.
Good. Part 2.
Yes,
Yeah,
sir.
part 2.
Very
Yes.
true. Okay. So as we discussed in our last webinar related to Companies Act, now today we will proceed with respect to SEBI LODR and ICDR. So what is preferential issue? So preferential issue means any issue of securities by a listed issuer to any select group of person, but it does not include an offer of specified security made through employee stock option scheme, employee stock purchase scheme, or an issue of sweat equity or depository receipt issued in a country outside India or foreign countries.
So it also very clearly go back, the specific security buyer to select on a private placement basis. That's what I'm always insisting, reiterating that private placement is a broad word, and within that the preferential offer comes. Okay, go ahead.
So now issuers who are ineligible to make a preferential issue. So that is transfer of share, 90 trading days rule, non-exercise of warrant, fugitive economic offender, and outstanding dues. So no preferential issue to any person who has sold or transferred equity share in last 90 trading days. But there is an exception, that is interstate transfer among qualifying promoter under SEBI SAST regulation, that is transfer due to pledge invocation by bank, NBFC, mutual fund, or IRDA registered insurance company.
Okay, I'll pass that. Let me just give a small thing here. The reason that, when you are talking about allotting to somebody, subscribing to somebody, when he has shown an interest to do it, the reason is it should not go back and see that he has sold and he is coming back for the subscription. That is one thing. Secondly, also compare this with the contra trade, which is under the PIT regulation. So that's the reason that this has been come. Very interestingly, Sudhakar, way back, SEBI has given an informal guidance that gift will also be considered as a sale. So interstate transfer and all should happen within SAST regulations, and that too for a consideration. Very interesting informal guidance given long time back in sometime in 2015 or 14, I believe. Yeah, please, Khadija.
Okay. Non-exercise of warrant. If promoter or promoter group failing to exercise previously subscribed warrant are ineligible for 1 year from warrant tenure expire due to non-exercise or warrant cancellation. Fugitive economic offender. If issuer is ineligible, if any promoter or director is declared as a fugitive economic offender. Outstanding dues. Issuer is eligible if it has pending dues with SEBI, stock exchange, or depositories. But here there is an exception if dues are under a pending appeal or proceeding accepted by a court, tribunal, or authority.
Interestingly, the fugitive economic offender ineligibility criteria has been given, but not the willful defaulters thing. As when it comes to QIP, I will say a small difference and how do we tackle this. We'll come to that, Khatija. But willful defaulter has not been mentioned as a part of this, whereas in a normal fundraising IPO thing, you have this willful defaulter also. Yeah.
Now, condition for preferential issues. So there are 5 conditions. That is, equity share allotted by preferential issue shall be made fully paid up at the time.
Sorry, Khadija, go back to the earlier one. Sorry, please.
Yes, sir.
So one of the things that we should also mind, friends, whenever we are passing a resolution in the board or in the board meeting, when apart from that 117(3), which specifically talks about the power to the board to issue and all, whenever these kind of things, ideal way is also to take note of that your eligibility and ineligibility. Please cover it in the minutes also in some form or other. It's a good way of bringing every fact before the board and minuting it. And that's one point which we may have to, we can start doing it. Okay, please.
So conditions, there are 5 conditions. That is, first, the equity share shall be made fully paid up at the time of allotment. A special resolution to be passed by the shareholder. Proposed allottees in the issuer are in dematerialized form, the equity shares. The issuer has obtained pen of the proposed allottee. Exception is exempt from specifying their pen for transacting in the security market by the board. The issuer has made an application seeking in principle approval to the stock exchange.
1 second, Khadija. Now, friends, this is a very important thing. We would request whoever is handling a preferential issue of a listed entity, unlike in a QIP, but if it's a pure preferential offer, this last one, which Khadija is talking about, the seeking in principle approval, the wordings which very clearly use that it has to be sent on the day when you send the EGM notice or the postal ballot notice seeking approval of the shareholders. Please, friends, this is a very important aspect. Do it, and in your checklist, please highlight this point and do, because this is one aspect we guys may miss it out. And please don't come in, because what happens is, though you may get a relaxation, penalty is being levied by stock exchange, and SEBI has very clearly instructed stock exchanges to. In fact, this fine, Sudhakar, for a change, it directly comes from SEBI. Even though, maybe 1 or 2 days, but nowadays they are also strict. Earlier, I had seen 2-3 days they waive, but in other cases, SEBI directly imposes a penalty if you don't do this. So please be mindful of this, and as a part of your checklist, please highlight it and keep this in mind. Yeah.
Relevant date, the most important topic. Preferential issue of equity shares, that is 30 days prior to the date on which the meeting of shareholder is held to consider the proposed preferential issue. And in case of any resolution of stressed asset under a framework, under the IBC, the date of approval of corporate restructuring package or resolution plan shall be the relevant date. Now, preferential issue of convertible securities, either the relevant date referred to in clause A of this regulation or a date 30 days prior to the date on which the holders of the convertible security become entitled to apply for the equity shares.
Okay. Just, a relevant date, as Khadija said, it's also a very important thing, friends. 30 days calculation, we normally try to lose this. Two things, as she spoke about the 90 trading days prior to that, please calculate your process of starting with the board approval for preferential issue, or even before that, intimating exchanges under 29 should start post that 90th day. First, let's understand that. Don't, trading days. So please go backwards, calculate those 90 trading days and start initiating only after that date. That's the first thing that you need to be careful of. Secondly, when it comes to the relevant date, English looks very simple here, but at the same time, when you set up a particular EGM or whatever the date, EGM, whatever the postal ballot thing, the notice, please go back and, count the 30 days very clearly about, again, it is about the trading days, which you need to talk about 30 days prior, not the trading days, 30 days. Be very clear when you calculate this 30 days. And in fact, my request is whichever exchanges, informally, you can also informally just have a word with them, because you are already announced to the market that you're going to come out with a preferential offer and etc. But my request is, because they have a system, in the system, they actually clock this and put the dates and see which one is, coming. So please, my request is informally have a chat with them. Just call them up and just have a chat. This is what I'm going to do. Is it just, I think both the exchanges are very helpful in that aspect of, please do that. That is very, and if the relevant date falls on a trading on a non-working day, non-trading day, you should take 1 day prior to this, 1 day prior to this. So be mindful of this. Relevant date English looks simple, but when you calculate, please sit down and do it. Similarly, 90 trading days. So in between, you should start the process. Yeah. Go ahead.
Ranga, just 1 minute, Khadija, please go back.
Yes.
So, Ranga, there is one question comes that 30 days prior to the date on which the meeting of shareholder is held to be considered the proposed preferential issue. That is the relevant date. So
Yes.
several times this question comes whether the date of the meeting and the date of the issue is to be, excluded or included.
Yeah, excluded.
They both are,
yeah.
Though the word they have not used the 30 clear days prior to, but still these 2 days are to be excluded according to me. I thought I will get it reconfirmed.
Yeah.
That is one. Second thing, Ranga, is that what is this? Kindly throw some light on this thing. And the stressed assets, when you bring a preferential issue, that resolution passed of stressed assets under a framework specified by RBI. What is this, sir?
So this is basically, though I have not handled practically, but this is basically, in terms of that. Well, let me recollect, because I did some time back, long time back, the date of approval. Okay, so the relevant date, how do you take the relevant date for this kind of, when a company comes under the IBC route, which, what do you call the date on which, it's the date on which the corporate debt restructuring package or the resolution plan has been approved by the COC. That's the date in which, once you approve that date of resolution plan, and that's, you need to go back and look for the 30 days prior to that, Sudhakar. There is
I'm not talking about the relevant date only, but I'm talking about the method. There is a preferential issue for this particular purpose. This is stressed assets. That's what I'm asking you. Suppose you can bring a preferential issue to deal with this particular stressed assets and other things. If you can throw some light on that particular aspect.
Okay. Let me tell you. See, whenever there is a stressed assets coming in, so there can be a new guy who is coming and investing money in this company, because IBC principle is not to close down. It is also for to revive the business. So if there are interested parties who wants to come and revive this company and wants to pump in money, he is ready to do it in a preferential manner. But what is the cutoff date, or what is the one he has to follow? There is a RBI framework that has been given. There are ifs and buts, lot of ifs and buts, Sudhakar, in that RBI framework. Who is eligible and what kind of a thing he has to bring in, how many, all those relevant factors are mentioned very clearly in the RBI framework. And based on that RBI framework, sometimes the resolution or plan also factors such a thing, and that is why they have used both. in case of any small changes within that framework, if the NCLT feels that it is in the interest of the company, then that can also be approved. So there is a very clear-cut framework that RBI has followed, has mentioned. So, and that's the reason it is talking about. So again, despite IBC coming into being, there is this corporate debt restructuring cell CDR mechanism of RBI. Still, it is on. That is also one of the things. So some company can go under that route. So in that case, again, see the CDR mechanism which RBI has laid down. That's why if you see Sudhakar 230 subsection, I'm talking about merger. They are specifically talking about corporate debt restructuring. In case of a merger. So that maybe they have not covered it in that words, but that's the reason this has also been given, because it's very important, because in a stressed company, I will come and invest in your company, whether it's a promoter or maybe anybody else who comes and invest, and that's why they are saying you please follow that. Don't follow this, ICDR in that case. That's why ICDR has given a carve out to that.
Okay, fine. Thank you. Yeah.
Ranganathan, somebody has actually put up a question here when you talked about the merger. In the case of the merger petition before the NCLT, which is at the final stage, can a transferee company with a listed company, which is a listed company, can actually issue the preferential issue?
Okay. Now, just to answer this, neither there is a restriction on the under the the Master Circular of SEBI, nor under the Companies Act, not under the ICDR 158 to 170. There is no there is no. But it only talks about a transferee company who is a listed company. Yes, it can always do. It can always do, because if it is a transferor company, then the transferee company is running the business in trust for the transferor company, and hence there might be some sort of small approvals, internal approvals between both the boards have to be taken. But in my view, transferee company can easily come out with a preferential offer when it is pending. And in fact, since you have raised this, one of the thing is maybe to safeguard everything, you can always include a clause, because this is talking about a transferee company. Absolutely, there is no restriction. But yes, once you have the NCLT CHAPA, I think most of the things would be covered. So it's better to include, if at all there is an enabling clause, you can include in the merger schemas as well. There is absolutely nothing wrong, because even the swap ratio, the price in which both are based more on the share price, market price, rather than if both are listed entities. So there is transferee company can come out.
And somebody is asking on the relevant date, is it the approval of COC or NCLT for IBC related date?
COC.
Yeah.
Okay.
Go ahead, Khadija.
Now,
one second. Is law same for issue? I didn't understand. Is law same for issue by subsidiary of listed company? Means what? Subsidiary of a listed company comes under Companies Act. You follow that. Right? There's nothing specific that a holding company being a listed entity should do, friends. Go ahead. Sorry.
Tenure of convertible securities.
Just one minute, Khadija. To clarify that, when they say that subsidiary of a listed company, unless until in the listing regulation there is any specific reference, the specific reference is there only with regard to material subsidiaries as far as the secretarial audit is concerned. Otherwise, other than that, subsidiary companies for all purposes are independent companies. Even if they are listed companies, the SEBI regulations are not applicable to them. Only Companies Act related provisions are applicable to them.
Correct.
Yes, Khadija.
Tenure of convertible securities that should not exceed 18 months from the date of their allotment. The issuer shall ensure that the allotment of equity share pursuant to exercise of convertible securities is completed within 15 days from the date of such exercise by the allottee.
Okay. So the convertible, the maximum convertible, the Companies Act doesn't talk about any tenor, convertible. You can have anything, but you can take a clue from this whenever we are thinking of, the management immediately asks us what is in your view. So don't get, please refer to ICDR please refer to ICDR. It gives you some sort of, but let us see this when it comes to QIP, completely a different picture, friends. But in a preferential issue, the convertibles cannot exceed at any point in time 18 months from the date of their allotment. No, from the date of their allotment. Correct. One second, go back. I wanted to just emphasize the insurance and the allotment of equity shares pursuant to exercisable is completed within 15 days from the date of exercise by the allottee. Okay. The only thing, let me also put here a point is that, if it is a convertible securities, need not be listed, friends. For a change, if you look at the preferential issue regulations, I have equity shares on one hand. I am coming out with an equity convertible securities on the other hand. This convertible security need not be listed, because if it is listed, then there is a small difference. But if it is not listed, so my request to secretarial auditors who are giving this reconciliation of share capital certificate, and also under regulation 24A of LODR, when you do the secretarial audit, please mention this point as a note that the company has issued convertible securities, convertible within whatever period. Please mention that brief terms and conditions in that. The reason being that when you are doing a capital audit, I think this will help in, finding out what is the correct picture about the capital. That's all. Though convertible securities, and the warrants, for example, warrants is also a forming part of your capital. But please mention that as a note in your reconciliation of capital and the secretarial audit very clearly.
I have one question. Suppose if you are issued securities, suppose equity shares on preferential basis, and the warrants are attached to that, is that warrants mandatorily to be listed, or
no need.
Voluntarily can be listed?
Voluntarily can be listed. Voluntarily. Yeah. My advice is don't list. Don't list. That's all. Because the moment, I encountered sometime in November 23 in one of the companies because the investors were foreign institutional investors, they insisted for this. So my exchanges were shocked to see, "Arey, kyun list kar rahe sir? Kyun list kar rahe? Isko bolo na unko." That kind of a thing. So better not to have this, but please mention it in your secretarial audit report about this impending thing.
In fact, when somebody asked me this question, I said that certain things are not prohibited, or not even in clear words permitted, but the option is with the companies only. So you have to see the complexities. What is the upside and what is the downside of going for this particular decision? So slightly complexities will be more if the warrants are listed. If you are prepared for that, by all means, yes, one can do it. But your advice is, according to me, the right advice, Ranga. Not to opt for listing.
Because most of them don't do. Most of them, because
correct.
So it's let's go with the let's go with the practice. That's all. Otherwise, there is nothing. See, I think some people are asking many things about the mergers. No problem. We'll take it 1 second. We'll take it then and there itself. It's okay, na, Sudhakar Bala sir?
Yeah. Please go ahead. Yes,
okay.
No
sure. Now, if you read Sudhakar, this one, what is the actual difference among private placement, preferential issue on private placement? What caution shall be taken to avoid this? Again, I think very simple. See, first and foremost is what we do in case of, at least in case of shareholders meeting, we copy paste somebody who would have already done it, right? And, correct, Bala sir. Nothing, in one way, there is nothing wrong.
No, you are rightly touched upon it. The only thing is, what happened while doing the copy paste, we don't edit it. That's a problem.
Okay. Now coming to the edit portion of it, many guys would read so many things. It is at that point in time, what is prevalent is what you need to take care of. Or in fact, what is it in future, if you want to take care of, there is a very clear provision. I think she would have covered in one slide about what are the different things that you need to factor. Adjustments to the price, that is already, it's a part of your regulation. But if you read without commas, full stop, you don't know finally which number and who is going to issue, right? So my only request is don't use all jargons. It's simple, 62 read with 42 and the rules. And if it is ICDR, whether you call it a private placement, whether you call it, the only thing, let me touch upon, when it comes to QIP, you have to mention it is a QIP. be mindful of that fact. Otherwise, private placement, preferential issue, I think, we use in all manner, friends. Again, to reiterate, private placement is a broad word. Within that, preferential offer comes. It's the same thing. That's all. Preferential offer is for equity and convertibles. Private placement includes your debt issue on a private placement also. So, sir, Bala sir, finally somebody is asking how to avoid adjudication being conducted by ROC in this manner. You can take it up next. But I'm saying you avoid this. It's a simple thing, friends. It's a simple thing. When you draft the resolution, you can look into the earlier guys who would have done it. No problem. But apna bhi thoda, wherever elimination has to be done, please eliminate those things and make it crisp and simple so that you convey what you want to convey. In a preferential issue, don't bring ECBs and etc. etc. Be very clear. Be very clear. Yes, there are two factors. When I inform the exchange, no company is very specific and intimation under regulation 29. That's fine, because suddenly the board feels something else, it might come. But when it comes as an outcome, be very clear, friends. What has the board taken? Whether it's Udhar bhi, don't go and again, don't do the same mistake. I think regular exchanges are coming heavily on this aspect. So be very clear. You can avoid all these things. There is nothing. In fact, next week, if possible, I will attend, sir. Bala sir, I want to know the basic difference, because nobody has explained me. Rather, I will take it as I have not understood. I will take that way, please, because all professionals, because day in and out they are doing, and they might be you. Adjudication, compounding, next week I will attend. You start the session with that, please, Bala sir.
No, we are going to talk. Our session is going to be between the difference between the compounding and adjudication in the first, actually.
First, please start with that. I will attend.
And then, we will do that.
Please.
One question that if you see in the Companies Act, the preferential allotment is under 62(1)(3) it covered, and it says that for all practical purposes, the procedure under section 42 is to be complied with, right? In case of ICDR, if I am not wrong, the private placement concept is not recognized as such. Only preferential issue is recognized. So now my question is, if a listed company is coming with a private placement, is the preferential issue guidelines of ICDR are applicable to that? If they are not calling it as a preferential issue, they are calling it as a private placement. A listed company is coming with a private placement of equity shares. Okay. So at that point of time, this ICDR preferential issue guidelines is applicable to that private placement or not?
Okay. Very simple, Sudhakar sir. You are a listed entity. You are coming out equity shares of a private placement. What is private placement? Is nothing but a preferential. You will get hit. That's what repeatedly I'm saying, Sudhakar, is private placement. It's like a simple example. Again, let me go back and say non-executive directors. You have independent directors. You have nominee directors. They are a subset of that. In fact, buyback is a subset of capital reduction. If you really see it, it is similar to that. Buyback, so notwithstanding anything, section 68 start with that, anything but at the same time, if you really analyze, buyback is nothing but a part of capital reduction, because there is a reduction of capital post your buyback, right? There is a reduction of capital. People confused with, capital reduction under 66, but there is so that's the reason it's also forming. So Sudhakar, to answer you, if a listed in two parts to it, if it is coming out with equity and convertible, you have to follow ICDR, though it doesn't use that word private placement. That is one. But yes, secondly, since you raised this, a listed entity coming out with a private placement of NCDs, for example, it has to follow only, it need not have to follow ICDR. But if NCDs are to be listed, there is non-convertible listing regulations. There is a separate chapter for private placement of, you need to follow that. You need to follow that. That's all. That's it.
In fact, in the minds of the several professionals, still, till now, in future may also be that the confusion of the private placement and preferential issue is definitely going to be there. And the main key takeaway from this particular webinar, apart from other things, is this difference, the way Ranga has clarified in the beginning of his talk, as well as even now also. More than this, nobody can explain that.
Thank you. Thank you.
I think by end of the day, the main key takeaway point from this webinar is what is the difference between a private placement and a preferential issue. Similarly, several times this question has been asked is that That's why before the question actually it is not coming in the chat box, I thought I will preempt Ranga about this thing. If a listed company comes with a private placement, so some people think that since the private placement concept is not recognized in ICDR, no need to comply with preferential issue guidelines, which is not correct.
It's not
Because
correct.
you being a listed company, you cannot do anything without SEBI regulations. That is a very clear-cut thing. So you have to comply with that. So Ranga has confirmed the same thing. So please, let us be clear about this thing.
Yeah.
Yeah.
In fact, indirectly, Sudhakar, if you see 62(1)(c), the rules, Rule 13, there is an indirectly, indirectly, directly, they are talking listed into, please go to ICDR. It simply says.
Yeah, correct.
So I think some of the questions are on merger, maybe. Merger, if Sudhakar and Bala sir invite me again, I will take a separate session on merger if they are inviting me. We'll see that.
Somebody is actually asking, can a record date for the issue of the merger consideration be same as the appointed date? That's what somebody
That
is
is a
asking.
different question altogether.
Because that is nothing to do with this. That we'll have to discuss separately.
Separately,
Yeah.
Because instead of that, if the case should be given, so Shilpa has written this, please talk to me with the case, no hypothetical questions, please. Or later on, not now. With, free of cost, I'll give you my advice. So, Shilpa, so you can take my number from Khatija and call me and, I will explain what is to be done.
Ranga, won't you do that thing the way I adopted a policy these days, 2 complimentary, thereafter it will be chargeable.
Acha. So, sir, good words, sir. Good word. I have no good words. So, can transferor companies issue shares after filing the application for transferor company after filing for merger as the allotment of sale? See, don't confuse.
I think now Khadija has to gallop because she had 50 slides. We are on the 7th slide only. Already 40 minutes are over.
Oh, otherwise part three people will get.
Yeah. Now otherwise part 3 will come. Yes, Khadija, please go ahead.
Yes, sir.
All these merger friends, whatever, I think that's raised by, I don't know. Anything, please talk to me later. I'll just give you a small, please go ahead.
Okay, so monitoring agency, if the issue size is greater than 100 CR, must be monitored by a credit rating agency registered with SEBI. There is exemption, that is to bank, public financial institution, and insurance company. Now, monitoring agency rule is to submit a quarterly report of until 100% proceeds are utilized and upload the same on the website within 45 days from the quarter end.
So there is 2 things in this. So when you talk about monitoring agencies, it is only credit rating agencies. Gone are those days when public financial institution could have acted as a monitoring agencies. That's the first thing we need to understand. Second thing, please, when you are doing an explanatory statement of a listed entity, please mention the objects for which you are raising it very clearly, because there has been instances where exchanges have taken their own sweet time to give their in-principle approval because of certain lack of clarity in the objects of the issue. That is one thing I just wanted to say. Secondly, also, if you have objects of the issue for a particular project or something which you can identify, the tentative time schedule, they are not asking you to give an exact one. Please mention the tentative time schedule also of that. That is very, very important. Third thing, you can use the preferential offer also, the GCP, that is general corporate purposes amount, cannot exceed 25% of your, the total issue. So these 3 elements are also to be considered whether when you talk about, when you mentioned about the objects of the issue in the, because responsibility is cast on the audit committee, to review the utilization of the proceeds. And hence, this is very important. Unlike in an IPO where you have a separate chapter for exit mechanism when there is a change of objects of the issuer post IPO, here there is no such thing, and it has to be monitored by the, when the monitoring agency gives the report, its responsibility is cast on the audit committee as well. Yes, Khadija.
Now, disclosure to shareholders.
So I just touched objects of the issue. So, because this is one point which I wanted to.
So disclosure to shareholder, key detail of preferential issue, that is the object, number of security issued, intent of promoter, director, KMP or senior management to subscribe, shareholding and control impact, pre and post issue shareholding pattern, percentage of post-issue capital held by allottee, and if there is any change in control, then regulatory undertaking and compliances, lock-in condition for non-payment of recomputed price, disclosure and certification, recomputation of the price, and completion timeframe of the issue. Disclosure and certification, that is independent valuation report, if consideration is other than cash, special resolution specifying relevant date for price calculation, and willful defaulter or fraudulent borrower status, current and proposed status of allottee, and PCS certificate before general meeting.
So two very important things I would see. Lot of scope for the practicing secretaries. Sudhakar, just to tell you, 2000, 2001, say I have been behind Mr. Narasimhan, those days, B. Narasimhan, that why should only a statutory auditor give this certificate? Thanks to whatever the initiatives that have been taken, now a PCS can also do. I think there are two certificates. One, to state that the issuer is in general compliance with all the conditions that have been laid down in this chapter. Second thing is also on the pricing mechanism. So that's one thing that we need to have. Now, willful defaulter and fraudulent borrower status, friends, when you give a certificate, take the backups of those things. At least, how do they say that this guy is not a willful defaulter, promoter and the director? Take a backup. Now, I think Sudhakar, so one of the major thing I just would want to, what's the next slide, Khatija? What is the next slide?
So that is related to pricing, frequently traded shares.
I think I'll come. Then I can speak in that slide. Go ahead.
Okay. Before going with the pricing, we'll go through the frequently traded shares meaning. That is the shares of the issuer in which the traded turnover on any recognized stock exchange during the 240 trading days preceding the relevant date is at least 10% of the total number of share of such class of share of the issuer, provided where the share capital of the issuer is not identical throughout such period. The weighted average number of total share of such class of issuer shall represent the total number of shares.
Yeah, so basically on the 240 trading days, you need to see whether it has been traded, frequently. That is on the at least 10% in the last 240 trading days is what you need to calculate and see whether you fall under the frequently traded or infrequently traded shares. I think the example given is also good. Relevant say is 13 and the total number of is 62 lakhs. So it is a frequently traded. Therefore, the shares of the company will come under because this is very important when you talk about a pricing methodology to determine whether you are frequently traded or infrequently, not frequently traded shares in this. Yeah.
Now, formula for volume weighted average price. The formula is total turnover for 90 trading days / 10 trading days preceding the relevant date divided by total number of shares traded during 90 trading days, 10 trading days preceding the relevant date. So where T refers to the turnover and V refers to the volume. Now, for the computation, the issuer has to open the trading data on the stock exchange. Enter the date up to the data is required, that is 90 trading days, and download Excel as required above and apply requisite formula.
It's a good slide, Khatija. This and the earlier one, I think you gave a very good example and you had explained. So it was very useful to me also. Last time when I thought last time we would have completed, but I didn't see today. But yes, last time I had seen it. Chalo, thanks for whoever has worked on this. Thanks for this.
See, the only thing is one slight disclaimer I want to put here from the form side is that this is only the indicative thing. Don't take it as the benchmark kind of thing. Okay. So let me put this disclaimer because tomorrow one should not say
absolutely
have advised it like this and all. So actually fixation of the pricing for the preferential issue is a very complicated one according to me. So I'm sure that your merchant banker is going to be there and he is going to advise you on this. Otherwise, also you can take a help from this, but don't take it as the benchmark.
Yeah. Okay. Just to tell you, sir, Sudhakar, sir, there is no merchant banker involved in preferential issue. So nobody is going. See, I think it's a very simple. I told about the what do you call the relevant date, you can just have a chat with those guys. You do your homework and go to exchange. Don't ask them to do, please. Many of us think that, it is their duty. It is not so. You do. I have seen it and I have done it also. When you take this and just take informally, you can have this because they have got the volume weighted, everything. They have a system driven, things you get it, Sudhakar. So it's,
But Ranga, though I agree with you, appointing a merchant banker may not be mandatory, but according to me, if I am not wrong, several companies do appoint a merchant banker as far as the preferential issue is concerned because of these complexities only. That's what I
it's some people appoint, I would say some people appoint, but more from, there is something called valuation report. Abhi to register valuer hua. File kya hota tha? There was this concept of fairness opinion also.
Yeah, correct.
Those things have gone now. Hence, yes.
Maybe.
Correct. If sometimes, or if they are not cost conscious, they can appoint a merchant banker. Anyway, go ahead. So good. Next, what is it next? Couple of things.
So now the pricing of frequently traded shares and pricing of infrequently traded shares. For equity share listed for 90 trading days or more on a recognized stock exchange, the issue price must be higher of 90 trading days volume weighted average price preceding the relevant date and 10 trading days volume weighted average price preceding the relevant date. And valuation to be based on book value, comparable trading multiples, and customer valuation method. Now, in case of pricing in frequently traded shares, the IPO issue price or valuation under a scheme of compromise arrangement or amalgamation.
No, I think, Khatija, this is basically, infrequently traded should come later because this is for a company. If it comes, under the ICDR, there is a restriction that a company that has come out with IPO cannot raise funds in any form for the next 6 months from the date of allotment in the IPO, unless they have made adequate disclosures in the RHP and prospectus. That's the condition under ICDR. But for a company that's coming through say a reverse listing, when a listed company merges with an unlisted entity, or you come out with an issue in less than one year, how do you compete? Or during the period of 10 days, if I'm giving a disclosure and if you're not falling under that, then this is required. Whatever the days to that extent, you please do that is what is this indicating. Infrequently, I think you would have covered in the next slide. You would have covered. But couple of things I just wanted to tell. Go ahead. Next slide, please.
Now, pricing in preferential issue of
I think stressed assets, we can slightly leave it, Sudhakar, with your permission, Sudhakar and Bala sir, because this has a different connotation and different way, and only people who are doing IBC will be interested in knowing this. So I think we can skip with the permission of everybody. We can skip this.
Sure.
Sure.
Okay, before even optional pricing. No, this has gone. Optional pricing, I'll tell you, I saw this slide. This was only during till December 2020 when due to COVID, some relaxations were given. This was one of the relaxation under ICDR for preferential issue. So this has gone now. This is no more. Only for those companies it should have done, it is applicable, but for her others, it has already gone. 2023, 3 years bhi ho gaya abhi. Literally, this has become redundant. Now, just what's the next slide? Otherwise, I want to take some very important. Okay, you finish this, then I will tell you.
So adjustment in pricing, frequently and infrequently traded shares.
Okay. So just to sum up this, Khatija, with your permission, just to sum up what it typically talks about it, especially in case of, what do you call, if you had issued a convertible securities, and before it gets converted, there has been some corporate action on the part of the issuer company in terms of whether, bonus shares, split rights, etc., etc. You need to factor that in the, for giving it to these guys also, because literally, de facto, they are the equity shareholders during that point in time. Hence, they should also be, for example, bonus shares, when you have taken that webinar, you would have definitely covered this also in whenever any impending thing, you need to give that bonus shares for those people also. It's very clearly written in ICDR. So similarly, here also, in case of any corporate action that happens, before you convert those convertible securities, please these guys also should be benefited out of it, and hence this is being given as a part of adjustments in the price. The second one is Regulation 30 of LODR. When recently when it come, before you announce a corporate action based on whatever there has been a huge movement. If there is a huge movement in the prices, you should know. The regulation is taking giving that certain things please ignore. Certain things please ignore and just look into them, and that's where they have very nicely, Sudhakar sir. Otherwise, it would have been only in what do you call LODR, and people following ICDR would have forgotten. But luckily, they have brought it here also. So ICDR may be agya. So please be aware of this fact. So any major price movement only due to this factor hoga to that could be ignored, and only the genuine trades for those calculating the prices will be taken into account. Yeah. Go ahead, Dr.
Now,
Okay.
other condition for pricing.
Okay, before this, let me go to that pricing. Just go back a couple of
Okay.
slides. Uske pehle. Frequently traded shares. Yeah, uske pehle bhi. Just go there. Go back. Okay. Have you covered? Just go up. There was this 4 verticals. You had put some 4 verticals, I think. Uske pehle shayad. Iske pehle. So here you are talking about different disclosures and other things, friends, but mindful of the fact, yes, preferential issue can be done for cash, which we all know. Now, please be mindful of this. This is a very important thing. I will give you a small case also now, the live case, So preferential issue, you can issue for consideration other than cash, and there is a way to calculate. If it is for other than consideration other than cash, you follow the financial models. Based on that, you arrive at a price, and the registered valuer has to give you a certificate valuation report. Now, typically, Sudhakar sir and Bala sir will vouch for that. When you talk about a consideration other than cash, you take some asset, whether intangible or tangible, and against that, you issue shares, right? This is what generally we all know. This is what is the principle of company law also, talks about. But there have been very good instances which are coming up, which are something, I think last time I mentioned about a company, I'm forgetting that name, forget it. But recently, friends, there is an informal guidance issued in one of the Bangalore-based companies, Eland Apparels. The very informal guidance. Now, what they have done, it's a subsidiary, it's a listed entity in India. Its holding company is based out of Singapore. So they have entered into a long-term contract with these guys for supply of so many things. So don't get into 188. It is all within ordinary and arm's length basis. Okay, let's presume and go ahead. So, they have been entering into, but now they don't have cash. They are not able to honor their commitment. One of the conditions is to pay advance also before they, import the goods. They have to pay some advance. So they are not able to pay. They approach SEBI for an informal guidance. First and foremost is they asked whether I can use this because advance maybe, what do you call, they have paid advance to us, but we are not able to supply, material, and we are not also able to pay them cash, So can I issue shares against this? And they are okay with that. The answer is completely no, friends, because you cannot adjust. You cannot issue equity shares against a pending outstanding liability. The only exception is loans. That's a different matter altogether. But that's why when you see 163.3 was amended sometime in 21, I believe, 21 or 22, there was a major amendment to a preferential, issue ICDR. 22, I think. It's 22, yes. So one of the thing is, consideration other than can be only for swap of shares. For example, I am acquiring, a company is investing in the form of a preferential issue. Instead of giving cash, it can give its shares. That's the only thing, swap of shares, that is allowed. Unsecured loans are allowed. But apart from that, don't go and say against trade payables. All those things are completely in one case. Sudhakar sir was. Can I adjust this? I think last time I touched, but never mind. Can I adjust this against salary payable to my employees for the last 1 month. Secondly, a very peculiar thing came. I mean, I'm seeing all these things now, interesting, but whether I want to give bonus to MD, I don't have, suddenly bonus to MD, I don't have money to pay. Can I issue shares against that? These are the question. Please, friends, completely negate kiya. So Eland Apparel is the latest one. Secondly, the beauty of this was, they said, we will issue only one share with a significant premium to the market price. Is that allowed? SEBI, of course, very diplomatically, they said nothing has been provided too much of detail. So informal guidance is that way. So they have said since we need more details, we are not able to comment. But however, it is not possible is what they said. But please, that is also one share, and against the same thing what I explained about that payment adjustment against the advance that the supplier the vendor has given. So this is Eland Apparels karke hai. That's a very 2-3 page order. I mean, not order, informal guidance. So this is one thing for consideration other than cash. Please, sometimes company law principle, you have to understand on your own. It is not that we come and give any kind of this against whatever we want to. Please understand, company law principles are completely different from other corporate laws. Hope Sudhakar, Bala sir and all will accept.
Yeah, absolutely.
That is why you have a lot of doctrines enshrined in the Companies Act. So please, other than consideration, other than cash, be mindful of it. Now you will go and ask me whether, ye to ICDR mein diya hai, but can I do it in Companies Act? Now, if you want to go for adjudication and other things, please do that. Now, somebody asked that, no, Bala sir, aapke liye main answer kar raha hu abhi se. Next session ka. So, please don't do that. This is one area, sir, I think you need to point out in preferential issue, consideration other than cash, don't. And again, loans also allowed. But please follow 62 very clearly. It talks about 62.3 very clearly. It talks about that if you have the intention to convert into equity shares, please mention upfront. Please mention upfront.
1 minute, Ranga. See, any kind of issue of shares against loans, if I am not wrong, it doesn't fall under consideration other than cash. It falls only when consideration other than cash is when any tangible or intangible asset is there. Though loans may be a balance sheet item, but still it is not considered to a large extent other than cash.
Correct,
Because
sir.
unless until there is a convertible clause is there, loan as such, for against private placement, it clearly says that the money has to come from a separate bank account. All those issues are there. So
Correct.
if at all the loan is there, the loan is to be repaid, and then that is to be again to be replenished back to the system, and all those things are there. So to a large extent, let us say that loan is not a consideration other than cash. Only apart from other things are there. As you rightly said, any kind of a revenue expenditure, that is a P&L account item, it will not come at all.
Yes. Just to add, only why I'm saying this point, Sudhakar, is what you said is absolutely, I was also bang on. I'll tell you some 20 days back that loan means, I mean, loan cannot be, usme bhi kidhar hai, all these things. But the only thing, exchange is slightly, flexible in that. The only thing is slightly it's flexible in that, because it's ultimately money has already come in, and so they are taking a slightly lenient view, but we need to go with case to case. As Sudhakar said, friends, these are all flowing out of our experience. It's our views. Okay, that's the thing, because consideration other than cash, Sudhakar, now it's being used very randomly. It is used, and I'm finding it very difficult to digest actually. Maybe looks like theoretically ye sab ho sakta hai, ye sab, but principle is something which we cannot forego, right? And that's the reason this has been. I just wanted to point out this consideration other than cash. Go ahead, Khatija. You can use the same thing for unlisted entities also.
In fact, let me tell you, Ranga, this loans, against, converting into shares and all, these are all shortcut methods to a large extent. What happened is, the loan is there. Now I am not in a position to repay the loan, so I will give you some, shares and all those things. These are all shortcuts. And these shortcut methods are to be done very carefully, because that, again, the same thing, how ROC is going to view that. And it also differs from ROC to ROC also sometimes. And you go and contest the matter, that is a later stage. But in the initial stage itself, why you want a kind of what's called, a confrontation with the regulatory authorities. So to
Okay.
avoid as far as possible, that is the
Okay.
objective.
Okay. Can you please share specific clause which should cover in articles for issuance of, as I said, please mention one clause that the company at any point in time can make a preferential issue of shares or other securities from time to time as envisaged under the Act. This is what one line, I mean, I'm just putting it in simple terms, but for a legal language, we can put it issue of shares, because issue of shares, is under the prerogative of the board of directors. If you see articles, I think it's a fourth or fifth item, automatically you should put it, friends. Please do that. Please do that. Next, 1 second, if possible, I'll just please share contact details. That is Khadija will do.
Ranganathan, you touched upon very right point. Exchanges are taking a lenient view at some time or something like that. What it happens is it all get into discrimination because they have the discretionary power, so it is being used. When it comes to the discretionary power, you cannot take it for granted. This will happen like that. As you rightly touched upon, that we should go in the right way rather than depending upon the discrimination. Oh, it may not happen, or let it see when it comes. These sort of the things we cannot take actually.
Yeah, case-to-case basis.
Yeah. And again, as Sudhakar sets it very clearly, there are different orders by the different ROCs in the same matter. That is also there, how they look at it. That is also
you take it up, sir, next week.
Yeah.
So somebody is saying again, throw light for the procedure for the startup companies also. Is there a startup company? Companies Act talks about private, public. That's all, friends. Of course, listed entity, you have private place, for a startup company, you say whether it's a private company or a public limited company, and follow the the sections and the rules that are given. It's very simple, friends. So whether there is a restriction between private placement IPO, there is absolutely nothing. So as I say, there is something called pre-IPO placement, which can happen even before you file RHP. The only thing, please be mindful of the fact that pre-IPO placement, if you intend to do, mention that intention in the DRHP itself. Otherwise, you will not be able to do. Can consideration other than cash include expertise services? No, boss. Then, all of us, all the firms and all the, advisors would be said that, please take my shares. Where will I go with those shares? No, that's what very clear. I think, see, you cannot issue other than the tangible and intangible assets one. Yes, to some extent, since exchanges on a case-to base or considerate about the conversion of equity, issuing equity against loan, that is permissible. But as Sudhakar very rightly cautioned, go by cash to cash, because that also defies logic. When you consider the lot of process that are involved in that. So that is the thing, friends. Now, Khadija has shown this. I would summarize with a case law for this, Sudhakar Bala sir, if you permit me.
Yeah, sure. Sure.
So there are two things, as I said, the ICDR had undergone, especially the preferential issue guidelines underwent a major change on 14th of January 2022. And this is all emanating from that. What is that case? If you can just, 2 minutes, I will explain very simple, how this has come in and how we should be careful in, what do you call, when you draft an articles of association, how careful you should be is what is this entire case. There is this PNB Housing Finance, which we all know. Okay. They came out with the preferential offer. They sent out the EGM notice. Everything was sent out sometime in 21 May to June. I think between that, everything happened. May and June 21, end of May and June, middle, dates, but yes, 21 May and June. So PNB Housing Finance, they did. What they did, it's a listed entity. They calculated the price based on, it's a frequently traded shares. So according to the pricing formula, it came to around 384 or something, 382, 383, 384, I think, if I remember. It came to 384. But what the law says that you cannot issue, your preferential offer price cannot be lesser than this. You can always issue at a higher price because you are issuing to only to a particular group of people. The company requires money, hence you can issue, is what is So they issued from 383 or 384 to 390 rupees. There is a difference of 6 to 7 rupees. There should not have been any problem in this. Electronic voting started. It was an EGM, electronic voting started. Understand, friends? So electronic voting started. On day one, when maybe in the night post 9:30, 9:40 is what I know. SEBI say there is a mail that is coming to the compliance officer saying, please withdraw this resolution. Please, stall this entire EGM is what, the mail that comes from SEBI. What will they do? If electronic voting has started, immediately, they went to SAT and said, this is the thing. SAT took only one thing, saying that don't stall the process. Don't stall the process. Let EGM get over. Direct the scrutinizer to put it in a sealed envelope and then hand it over to SAT at an appropriate time when we direct. This was the thing that SAT made. Now, what was the contention? What was the contention? Why did SEBI came out with this? Preferential issue, Sudhakar sir, you need not have to file anything with SEBI. Anything with SEBI. It's only with the exchanges you go take their approval and other things. That's a great flexibility you have in preferential offer or issue. Now, where does the SEBI, though it is governed under ICDR, they came out and stalled the process. Now, the issue that came was, prior to that, PNB was almost holding around, around 68% or something in the PNB, the main holding company was holding in this housing finance company. And this private placement was to be placed with a lot of private equity players like Carlyle, Salisbury, or General Atlantic. All those people were the guys who were the identified prospective allottees. Okay. Now, if had the allotment been made, then PNB's stake would have come to just hanging around 20%. Okay. Now, two things came. They said that means there is a complete change in control over this. How are you doing it through PNB? So all those takeovers, etc., is one thing. But though PNB was trying to say control is with us, that's different. But the second important factor, friends, this is where I would really require everybody's attention, please, for a minute, is that they said, please, boss, go and look out your articles of association. What does that say? It says that in case of a preferential offer, I will go with my book value calculated through a valuation method. If that price is more, I have to adhere to that. It says I have to follow that also. So they SEBI pointed out this. When you calculate according to this, it comes to around 540 rupees. So your issue should have been at 540 and not at 390. Now, this is the contention, Sudhakar, Balasar, Katija, and everybody, all my friends over here listening to this. The contention was, I'm a listed entity. I'm following the regulation. There is a pricing formula fixed. I have followed that. Why should I follow articles? Okay. Now, went to SAT. Interestingly, it was a split decision, Sudhakar. So what had happened is the presiding officer said nothing to do with articles. They have followed very strictly the ICDR guidelines. Then they should go ahead. But there is the judicial member took the other way. Judicial member actually say that, he told that the articles, whatever the methodology and the price that has been mentioned in the articles should prevail over that. So if you look at the change that has come in post this on 14 January 2022 was, first, they have introduced a clause that you do this pricing and all, but if your articles mention some valuation methodology due to which your price is higher, that should be counted. That's the first thing that they talked about. So friends, my request is when you draft an articles of association, it's left to you. It's left to you whether to mention this clause or not. If you are silent, all the more better. You will be restricted only to these guidelines, that pricing guidelines that ICDR has given. You need not have to look into your articles. But be mindful. That's what I'm saying. Preferential issue of securities, please, there should be an authorization in the article. Secondly, if at all there is a valuation methodology before you issue in case of an equity shares, please follow that. So finally, what had happened, it was a split decision. Finally, PNB Housing went for a settlement and got it done, and no allotment, the entire allotment did not happen. Now, another couple of factors that came in out of this was, if there has been an allotment of more than 5% post the listed issue, or if it results in change in control, it requires, irrespective of whether you had mentioned it in the articles or not, please go and take a registered valuer's certificate and find out. And if that price is more, you need to offer it at that price. So 2-3 things mentioning in the articles: change of control, more than 5%. Now, if you look at, there is also an independent directors meeting that is required. I think, where have you covered that? It should be here somewhere. It should be here. Independent directors meeting is also required. I'll just tell you, 164, right? Okay. Here also the independent directors have to give a recommendation if there is a change in control. Just any preferential will be made to recommend it. Please, I think last line, last paragraph. Any preference which may result in a change of control of the issuer shall be made. One last paragraph, Khatija. If you take the cursor down, yes, exactly. Shall be made to a reasoned recommendation from a company after the voting pattern of the undisclosed in the and all aspects. The only thing here is all the independent directors have to be present. I think it's a naya, but all the independent directors have to be present. It's not like your annual meeting where independent directors can skip. So this is another thing which has come, where the role of an independent directors is also to be seen. When you talk about independent directors' role in terms of the pricing, one in the takeover code, second under the pricing, and also in the IPO. So throughout, independent directors are also to be kept. This is the major change that has come post the PNB Housing Finance episode, preferential issue episode. I just wanted to highlight at this juncture, because that is why these changes have come in, Sudhakar, Balasar, and Khatija. So that's the thing which just wanted to highlight. This is what sum and substance of this entire thing. Go ahead, Khatija. We are running short of time also. Go ahead. Next slide.
So Lockin Requirement. So as per Regulation 167, lock-in of pre-preferential shareholding and others shares allotted pursuant to the issue. So promoter and promoter group from the relevant date, that is up to 90 trading days from the trading approval, and end date must be up to 18 months from the date of trading approval. For non-promoters, up to 90 trading days from the trading approval, and end date up to 6 months from the date of trading approval.
Okay. Again, so just to put it, I think she covered in 2 slides. Next slide is also on that. Very beautifully, she has narrated this in the sense, very simple, friends. Like an IPO, in case of an IPO, what we do when you talk about a lock-in, just promoters and non-promoters, that is existing shareholders, if any, prior to IPO. What is the lock-in period? The same thing is here, 18 months and 6 months. Not more than 20% at any point in time should be locked in. Third aspect. No, but what is that in case of convertibles? What is that in case of 18 and 6 listed, unlisted, securities, which I'm saying because, as I said at the beginning, convertible securities need not be listed, but uska bhi lock-in hai. Okay, so you just put that listed equity shares, promoter, non-promoter, 18 months, 6 months, not more than 20% is locked for 6 months, others for 18 months. At any point in time, it should not be more than 20%. This is for promoters. Non-promoters, simple, it is only for 6 months. When it comes to convertible securities, that's what Sudhakar, I said, better not to list. It's very simple. 1 year lock-in hai uska. That's all. Baad mein, on conversion, that will be again for, depending on whether promoter or non-promoter, 18 months or 6 months. So she has prepared this way. I had prepared in a different manner, explaining promoter and, So this is slightly a catchy thing. If you look at preferential issue of listed entities, 1, relevant date, 2, 240 trading days, 3rd, the pricing, the lock-in. These 4 very crucial factors, friends. Others are in terms of disclosures. These 4 factors, I think we should be mindful of this. Don't expect your finance team to do all this thing. It is our bounden duty to do this. And we are capable and we have to do this. The entire process, we have to do this. And that is where I think we should thank the Institute for recognizing and it's only the practicing secretary that can give a compliance with these provisions of this entire chapter, right? So good, Khadija, go ahead, please.
Okay. Now, document required to be submitted to the exchange for making in principle application. So these are the key points which I have mentioned. Lock-in period starts, that is the relevant date and continue 90 trading days. That is trading approval date, allotment date. Pre-preferential shareholding lock-in. The entire pre-preferential lock-in of 90 trading days from the relevant date. And if the shares are pledged, the lottee must obtain an undertaking from the lender, that is bank or financial institution, that the pledged share will not be sold or transferred during the lock-in period. Exchange compliance, that is a lock-in declaration mandatory for in principle that need to be submitted to the stock exchange. Promoter transfer during lock-in, that is interstate transfer, that is also to be permitted during the lock-in period.
Yeah. So only one thing, the resolution that you pass under 62(1)(c) is valid only for 15 days after the shareholders' approval, and then you need to make an allotment has to be done. If you are doing an equity shares, preferential offer of equity shares, ensure that the allotment is done, of course, subject to receipt of statutory approvals if any, I know. So you do that allotment, but go for the final listing approval within 20 days, friends. It doesn't come from this chapter, but it is under Schedule 19 of ICDR. So please ensure that you make that final listing application for trading and listing and trading within 20 days after allotment. Okay, go ahead, Khadija.
Now, transferability, transfer among promoter and promoter group, and the restriction on transfer of preferentially allotted securities. Promoter's lock-in security can be transferred to other promoter or promoter group members. A new promoter or person in control of the issuer. The lock-in period continues with the transferee for the remaining duration, subject to the compliance of SAST regulation. And preferentially allotted security cannot be transferred until trading approval is granted by all the recognized stock exchange of the issuer equity shares are listed.
Okay. Somebody has raised, I just saw this, how to calculate post-issue shareholding when you do preferential issue for promoters. As in 1 year, promoter can acquire only 5% of the. So simple, friends, it's post the preferential offer, you calculate the capital. And during that financial year, acquisition in any form, whether it is through a preferential offer or through a secondary market purchase, everything will be counted for the purpose of calculating your 5% thing. So when you calculate post issue, you know preferential issue mein kitna ja raha hai. And then what is the gap that is available for the promoters to acquire from the market during that particular financial year. That is how you need to calculate. Okay, so very good questions, but please also before somebody says apna homework karke talk to somebody, please. Then it will be very easy for everybody to, because sometimes I feel, Sudhakar, we are very, very strong. I will tell you the way I know we guys calculate, we think of the things. I'm literally to acknowledge our own profession. But the only problem is somebody comes and says something and we are not able to articulate in the manner which is required. That's the only thing. Otherwise, I think we know very clearly. Calculation be friends. Don't get afraid of. Don't get scared about the numbers. No number kuch nahi. It's all small mathematics. We need to go back and see. Now, ajkal Excel will give you everything. Sir, you are unmute karo, sir. Sudhakar, unmute karo.
This I am saying for the last 40 years that company secretaries are notch above everyone, if not below. But the only thing is our mindset. The ability to articulate is not up to the mark. That's what we have to improve upon. So in several forums, I have said this particular thing, that unless until we change the mindset, it is the right time for that. And develop our ability to articulate. As far as knowledge is concerned, we have abundant. The only problem is about the articulation.
Yes.
Ranganathan, this has been actually seen in the various NCLT cases.
Yes.
I think in one of the cases, the judge himself will ask the opponent, who are you? Are you a liar? He said, I am a company secretary. That is why you are not talking anything.
So, but sir, let me also tell, what I emphasize on all the fora, and I'll take this opportunity also, is we are the best people to interpret corporate laws. One who has a very good, understanding of company law principles will be able to do anything under the corp, because the word corporate again is from company side, right? So ye kya hai? A person has already provided some money to a private on the understanding that he will be allotted shares in the company. Can the company issue shares on a preferential basis to that person who has already paid the company on the understanding that he will be allotted shares? So वो separate bank account नहीं है, कुछ भी नहीं है इसमें, right? On the understanding. So if a person gives you money, whoever has raised this, first and foremost is it will go to the normal bank account of the company, right? How will you solve this? This is a procedural lag. So this is where adjudications, everything will come up, Bala sir. This is where we all slightly, maybe some real guidance will also be
Ranga,
required.
this is like advance against share application money. This concept
So-
was not there under the old Act, 1956 Act. Clearly, it was not there. Several companies used to say that at that point of time. But under Companies Act 2013, they have used this word advance against share application money. So this is more or less that kind of a question, but it is better to avoid these kind of shortcuts again, as we said earlier. If you are giving a money to a company, that means the board should have a proposal to issue the shares.
Issue the shares, yes.
Because otherwise, what will happen is that interest-free loans and all those things will come. So sometimes what happens is within the group, when you are circulating the money, what you will do is that it is like advance against share application money. And similarly, also to what's called ensure you are not falling in the deposit rules and all. Again, if at all you are using this methodology, the concept against advance against share application money is there under the 2013 Act. But you have to be very, very careful. Unless until that other company has a proposal for issue of shares, you cannot say this thing is advance against share application money. So one has to be very careful, avoid as much as possible these kind of shortcuts to what's called play with the provisions under the Act, to play with that thing.
So,
Yes, scope is there to do it, but you have to do it very intelligently and very carefully to
Absolutely.
avoid next Sunday's what's called as our this webinar.
No, correct. I was about to say that, it's possibility hai, but documentation, the process, it should be very clearly enunciated. Okay. Yeah, Khadija.
Now, consideration and allotment, I have bifurcated in 8 simple points. So, full payment at the time of allotment. If the specified securities is other than warrant, must be fully paid at the time of allotment, except when issued for consideration other than cash. Payment structure for warrant, that is 25% of determined price must be paid. Remaining 75% must be paid at the conversion to equity share and the forfeiture clause. Payment source compliance, consideration for specified security paid in cash must come from allottee bank account. For joint holder, payment must be received from the first applicant's bank account. Statutory auditor certification, the issuer must submit a certificate from a statutory auditor to the stock exchange confirming the compliance.
Okay. The only thing is be careful with the warrants when it's also securities because Companies Act doesn't talk about what is the minimum and everything, but under the ICDR, at least a minimum of 25% is required. And if you do not, so for example, when she touched upon the initial thing, if a promoter or any guy to whom warrants have been issued and he had not exercised that, and again, you are trying to issue on a preferential basis, that is not allowed. So that is one factor that you need to keep in mind. And if you do not pay the remaining amount to get the equity shares, then the entire amount will be forfeited. The entire amount will be forfeited. And there is no exemptions to this. And don't go to a SEBI for taking exemption for this. You will not get, because it's not a general exemption that SEBI will think of giving. So please don't do that. Okay. Yeah, Khadija.
Allotment timeline. The allotment must be completed within 15 days from the date of passing the special resolution. There is 2 exceptions. That is, if regulatory approvals are pending, then 15 days prior start from the date of approval. If SEBI grants relaxation under SAST regulation, the timeframe specified by SEBI applies. Fresh special resolution requirement. If allotment is not completed within 15 days, then a new special resolution must be passed, and the relevant date for pricing will be based on new resolution date. Open offer.
Simple. That means it's valid for 15 days. Otherwise, a fresh resolution pass karo is what is.
Then again,
Open
you have to
offer
start all
consideration.
over again. That is the issue. Yeah.
If the preferential allotment triggers an open offer, the 15 days period is counted from the expiry of open offer period. If an offer is made, the expiry of the time specified in SEBI SAST on receipt of all statutory approval if no offer is made. Allotment format, that is, allotment must be in dematerialized form only.
Yeah. Okay, go ahead.
Now, some key pointers for post-allotment. Allotment must be completed within 15 days of passing resolution or date of receipt of in-principle approval from the stock exchange, whichever is later. A statement of holding to be provided that is duly certified, issued by depository participant, reflect lock-in date and entire pre-preferential allotment holding, full consideration of security other than warrant. Then application to seeking in principle approval and post allotment shall be submitted to stock exchange within 20 days from the date of allotment of equity share specified security seeking listing.
Yeah. Go ahead.
So,
all these things.
yes.
There are a number of things that, go to the exchange website. It will also give you the entire checklist to be done, the format of the PCS certificate that is to be given, all those things are. But let me also tell you, friends, when you take that certificate, the format, ek bar pad lo.
Yes.
Because I think exchanges give you that small flexibility of changing it depending on case to case basis. So for example, in one certificate, it says that, the intention, when I'm giving it to the promoters themselves, it says that they are not holding any. There is a statement, Sudhakar, saying that the promoters do not, or the prospective allottees do not hold any shares. But I'm giving it to there is no exception also. I'm giving to the promoter, they are holding a huge chunk of shares. How do you word it? So we spoke and they said, you can always change it. This is just giving you a small format for you to do it. So all those things are possible, friends. So please read that before you go ahead and do it. Yes, next we'll go fast.
So there is one more point which I want to mention. The permission of you and panelists. In case of in-seeking approval, many times we skip the valuation report checking. So we forget that the valuation is taken from the day before the relevant date. That need to be 1 day prior to the relevant date. So if my relevant date is of today's, so 1 day prior is yesterday.
Correct.
So that is being skipped. So that needs to be taken care while giving the PCS certificate.
Oh, please. Good. Take it. Yes. Next.
So now, SEBI ICDR regulation with respect to qualified institutional placement.
So let me just give you Khadija, sorry, I'll give you a background to this. What is QIP? Is qualified institutional placement. Again, it is a placement, sir. Either placement use kar rahe Sudhakar. Either the word used is placement. So again, it is nothing but a private, under the umbrella of private placement. Now come to listed companies, there is preferential offer. Within preferential offer, you have another subset called preferential issue made only to QIBs. And that is what is called as qualified institutional placement. You need to follow the entire process of 42, whatever it is, wo sab hai usme. But some small changes because you are giving it to QIB. So all the more you need to be careful about this. Now, why this has come is an interesting story, Sudhakar. Because it came in sometime in 2006, if I am able to recollect. Because if you remember those days, early 2000 and till 2006-07, many companies were going abroad and taking money through ECBs. No doubt.
ECB and FCCBs.
FCCBs. No doubt, the what do you call the cost of borrowing was much lower than this. then, but there are a lot of ECB mein bada problem is you cannot bring the money into India. You will have to use it abroad for acquisitions or whatever those things. That was one of, except in case of capital expenditure, and there was a limit of that also to be. So then what was the use? And lot of FEMA compliances were also there. So then the regulator felt, see, when you go to ECB and other, it's all the financial institutions, foreign guys who are giving us money. It's not individual who are going to give us money. So why can't we come out with one concept of and make them stay in the, in the Indian market? And why don't we have a special route for QABs to come and pitch for this? And that is where the concept of qualified institutional placement came in sometime early 2006. And I think the first company that came out with QAP, again, my memory, again, it's Akruti Developers. Sometime in August 2006, they came out with the first 6 or 7, whatever. So the first time they came out. So the concept of QAP is nothing, for friends, for a listed entity. When you are going and seeking money only from qualified buyers, qualified institutional buyers as defined in ICDR, you can follow a separate process. Now the question is, can't they come under preferential allotment? Yes, they can do, but things are completely different. They are also allowed to. It was not there, Sudhakar, earlier. Now it's 2 years back that has also gone, and they said you can also come and 1 or 2 you can come and join. But QAP is a different. It's an easy process also, and you are giving it to informed investors. So all the more slightly almost the process is same except
in fact, Ranga, you see one more what's called as the reason for this introduction of this QIPs is that whenever you require funds, if you are going into the retail market, then suppose with the preferential allotment means only to the mostly to the promoters only. Suppose if the promoters are not in a position to infuse the funds, then you have to go to the private placement route. In the private placement route, what happened is you have to take the money from so many retailers. Instead of that, why can't we have a carve out for the QIPs? That means these are the ones like mutual funds, insurance agents, pension funds, and all those things. They have bulk funds. So you are going to focus on only 5 to 6 people. They're not going to be 50 to 60 people.
So 2 things. Absolutely, Sudhakar. And secondly, the image or the credibility of a company with huge FII holdings and QAB holdings is far better than a company which is, that is one. Thirdly, they also have a skin in the game in the sense if I had acquired shares from the secondary market, I don't have Ditna. But here, when I'm investing money, the money comes into the company, they have a say. They have a say. That's what, if you look at all the investors conference and analyst conference post the results, it is these guys who talk much, they are interested in that, So that's the reason QIP is
mainly another 2 things will happen when you go for QIPs. When the QIPs invest in your company, the image of the company in the stock market will go further high. Because the investor, that the QIP investors' confidence in your company itself shows that it is a compliant company and giving importance to the corporate governance related issues. So every Tom, Dick and Harry cannot make the QIPs, because QIPs, if they want to come to your company should be a compliant company and it should be having an impeccable governance norms in place. When the QIP is making an investment in your company, the image of the company in the stock market is definitely going to get a boost of that thing.
Yeah. Good. The another thing, if you look at QIP, if you look at section 42, subsection 2, it gives a carves out an exemption of those 200 people in a financial year.
Correct.
2 people, 1 QAP, if you do a QAP, and for ESOPs, So that is also, it's the latest one, but the story behind why QAP has come, why can't it be part of this? This is the story behind the QAP coming into picture, friends. Yes, Khadija. I think people are slowly from 215, it has come to 184 number of people who are. So, chalo.
You have to provide breakfast to the participants.
Mehta and Mehta should provide. Atul bhai ko bol do, Khadija. That's the feedback. I will put a feedback in this.
If you see in Bombay study circles, they always start with a breakfast, So webinars also we have to start with a breakfast. Yeah.
So eligibility condition for QIP, shareholder approval must be passed, specifying the allotment is through QIP, the relevant date, and there is one exception, no shareholder resolution is needed if QIP is done via offer for sale by promoters to mean minimum public shareholding norms.
Okay.
The validity.
I'll just tell you this, Khatija, because this is very important, which I have encountered when I was in Edelweiss. One of the thing is when you do this 62(1)(c) resolution, and if you're giving it to QIB, sorry, mention it that it is through a QIP. These wordings are very, very important, friends. These wordings are important. Secondly,
because especially when you want to get that exemption under 42, that 200 people.
Okay, that's also. But even this has to be mentioned very clearly in your explanatory in the resolution itself, that is by way of a QIP. Secondly, I don't know whether you would have covered elsewhere, but let me take this. There is a small 5% discount, maximum discount that you can offer it to these guys. Assuming while calculating the pricing formula, it is not 90 and 10 trading days here. It is 2 weeks before the board or the committee's approval date. Supposing it comes to around, say, 300 rupees, you can give a 5% discount to that, and you can offer it at between 285 and 300 rupees. So that is, but that fact needs to be mentioned in the resolution. Friends, again, I would reiterate, drafting resolution, QAP, Sudhakar sir, merchant banker is compulsory. He helps. But what typically merchant bankers do, they have a law firm to do all these things. But again, with their expertise, they are doing it with their experience. I would say more than expertise, their experience. But again, what they will also try to do is copy paste the earlier things, right? So here, don't shirk the responsibility of owning the drafting of the resolution is of the company secretary. Don't shirk that responsibility, friends. You can't be blaming anybody. So my request is you go through it irrespective of whoever has drafted it, and see whether you are covering each and every point that is, that is mentioned in the regulation. These are all very finicky things because you are public facing, and when you go to the stock exchanges, all these things will, bother you much. Hence, I think the groundwork needs to be done, irrespective of whoever drafts the resolution and the explanatory statement. Please let us do. Our job is not only to see that notes portion next to the notice. We have to be very clear in drafting. Yes, go ahead.
In fact, Ranga, that at the time of our rights issue and bonus issue webinars, we emphasized the same thing. Whenever you are passing the resolutions, though you can take what's called as a reference to other resolutions, but have your own resolution. Don't do that simple cut paste kind of thing.
Ranganathan,
Application of mind is very important. Yeah.
Ranganathan, you're touching upon the very, very valid point. What happens is people keep on writing the history and other thing and all the preamble to the resolution. But when it's come to the operative portion of the resolution, the main thing what is required is actually missed out. So ultimately, what happens when you get the certified copy of the resolution, that resolution is actually silent.
Yes,
that is the
please.
issue here. So it is a drafting has to be very, very thing. Sudhakar has emphasized in n number of forums the importance of the drafting, that we need to be careful. Yeah.
Okay. Second point is, exception. She has mentioned about the exception, no shareholder resolution. Now, let me tell you, there are, if you look at SERR rules 19(2)(b), which talks about the minimum public shareholding limit, we all know 25% hona chahiye public ke paas. But there are certain other things. There are 4 things in 19(2)(b). So an issuer, when it comes with an IPO, can be in any of those 4. It's 25% or between, 90 to 75 or even slightly exceeding 90. But there is a calculation who can do this in an IPO. But all those guys have to bring the minimum public shareholding limit to 25% within a period of 3 years. That is what the rule is. Now, long time back, it was, there are only different mechanisms. There are some 8-9 methods which SEBI has listed down, which you can consider. Apart from that, you can also have your own way of restructuring the things and, getting, achieving this part of the minimum MPS limits. Okay. Now, apart from that, one of the things that was missing is this particular thing, because there you have promoters, they give it through the exchange mechanism, what you call offer for sale through stock exchange mechanism. There is a separate chapter, not the chapter, there is a separate process for this. That is where a lot of companies were offering and bringing the minimum public shareholding limit. But if you do a QIP, instead of doing a primary issue, you can do a secondary transaction 2 QIBs, and that will also be considered as achieving the purpose of minimum public shareholding limit. That's what is being talked about here. So a new concept of QIP, when we say it is a primary issue, but there can be a secondary transaction, but it has to be two different things, friends. You don't club issue and secondary transaction together. So that is another thing which has come out, which is a new thing which has come out. And I don't think so far, at least to my knowledge, some companies have come out, maybe would have come out, but
Ranga,
I'm not.
Ranga, 1 minute. See, we are left with 15 minutes only,
We'll finish.
and Khadija is left with almost 16 slides more.
I
So
will
what I
cover very
request you is that she will go on putting the slides. Whatever the important points are there, please explain that, because let her not do it. You take the driver's seat now and drive it in such a way, 15 minutes flat. We have to reach the destination. Okay.
Sudhakar, that is what I mean, Bichari, she is thinking what this guy is keep on talking about.
No, not to
sir.
worry.
No,
No,
sir.
that's
Not to
what
worry. Khadija,
Sir, I'm
Yeah,
also
go
picking
ahead.
up only the main things. For example, this offer for sale,
Yes.
all those things I'm picking up. Now, allotment can be completed within 365 days as opposed to 12 months in a QIP, as opposed to a preferential issue here. The gap between QIPs should be only 2 weeks. Earlier it was 6 months. Now it is 2. Now go ahead. Next
So
slide.
now what I request you, Ranga, is you take the driver's seat, you ask her next and all,
Next,
and then
next.
you finish it up.
Next,
Yeah.
next, bus. So again, the ineligibility is if you are a promoter or economic, but willful defaulter. That's what I wanted to tell you. Willful defaulter, a company that is a fraudulent borrower or a willful, you can come out with a QIP provided you give the declarations as mentioned in schedule. I think schedule 17 or somewhere schedule 7. Sorry, schedule 7. You mentioned that, and you can go ahead and give your QIP. Don't hesitate if a company is coming under that. Schedule 7 gives you leeway out. What are the disclosures requirement? Go to the next one. Restriction on consecutive. That's what I told. Already covered. Promoters already be covered under the first one. Trading restrictions, like what do you call what we saw it in the preferential. There is also a slightly and especially if the promoter is a QIB, then you have all these kind of trading restrictions of gap between how to what extent you should have given and when do you come out. And QIP should come only after a year, friends. You can't just come out with this. Yeah. So there is a gap, and the trading restrictions pre-QIP is what is being depicted here. So please follow that very closely before doing this. So whenever this kind of an exercise comes, please let us take it as a project. Let's put it whatever way you want to do it. But micro level details is what you and I have to focus on. Yeah. Next, Khadija. Again, similar to Pref, if it is more than 100 crores, you need to have a monitoring agency which is required to be submitted. The same thing, reporting to to the audit committee, and in turn we submit to exchange, all those things. I believe now that reporting of monitoring agent, I don't know whether it is forming part of integrated reporting, Sudhakar. That's the only thing I'm not able. Maybe it could. Yes, I think it is forming part of integrated. Fine, go ahead. Lead managers, like a QA, like an IPO, lead managers are also very important in this case. Again, like an IPO, they have to give you a due diligence certificate. The major differences in a pref and a QIP is pref you just have to follow what is there in Pass 4. But in a QIP, apart from Pass 4, there are n number of things which Schedule 7 gives you to do this in terms of management discussion analysis, the financial results. In pref, I need not have to do this. Here, I need to give at least previous 3 years audited results, and also the results, the limited review report that you would have undergone before for example, today if I'm coming, at least the February, December results have to be given. Today, if I'm doing a QIP, if I'm preparing a Pass 4 or what you call as pre-placement document and a placement document. Pre-placement document is nothing. I'll simplify, Sudhakar. Pre-placement document is nothing but the Pass 4 placement document that I need to give it to QIBs, serially numbered. And the final one is when I do the all the process, because again, this need not be filed with SEBI. It is only with exchanges that I need to file with exchanges when I do
Put it on the website.
Put it on the website. And so these are the pre-placement and the placement document is something which is, but this contains so many things. For example, the financial statements, the limited review for the period, that is what we call in IPO parlance, the stub period, that you put it as a part of your placement documents, the MDA, business analysis, everything will form part of this. Actually, a mini, I will say, 15-20% of an IPO process is what, in terms of the diligence exercise that you need to follow as far as a QIP is concerned. But very interestingly, friends, here, the eligible securities. Can you go to eligible securities, Khatija? That is what is very interesting, Sudhakar.
Before you go for that, Ranga, I want to add just one point. In case of IPO, what happens is when you are issuing the prospectus, most of the times, apart from the retail public, when they are putting application, nobody reads your document. Whereas in case of QIP, everybody is going to read every word of your document, what is going to be there in that. Because
Yes.
QIPs are nothing but banks, financial institutions, mutual funds, these kind of people. They know in and out of this thing. And so you can't bluff them. I mean, pardon my saying that. What I'm trying to say is you have to be very meticulous while you are drafting the offer document itself.
Why require a merchant banker? That is where the marketing, more
Yes.
than the due diligence, a marketing thing that is. You find in
Absolutely.
QIBs, lot of foreign merchant bankers coming and, being lead manager. Just go to eligible securities.
Yeah.
I think somebody is saying only 10 minutes left. Please continue for another session. Oh, fine. You only will get bored. Whoever has returned. Chalo. Go. Uske pehle. Eligible security. No, I think you are not covered. So eligible securities are, 3 different types here. One, pure equity. Then please understand, non-convertible debentures with warrants. Third one is convertible securities other than warrants. What does it imply? When you are doing a QIP, if you want to issue warrants, I can't issue independently or separately what could have been done in a preferential offer. Okay. If I have to issue warrants, please do that along with NCD. Why this has come again, Sudhakar, going back to those story what you and I spoke about, those things, the QIBs at that point in juncture felt that fine, we were ready to invest in QIP, but why can't you have some kind of a different, I will not call it a hybrid instrument, it's a different instrument. One, having the full features of a debt instrument. Two, having the features of a quasi-equity, that is what warrants. Why don't you club and issue together so that what will happen? The advantage to the company is I can issue NCDs at a lesser rate than what I would have issued if I had issued only NCDs. The second advantage to the investor is that he is getting a stake in the near future. So it's that's why this instrument was also been given. But if you're issuing any other convertible, you can't club it with warrants. Now, assuming a company issues NCDs with warrants, you as a subscriber, a QIB, can choose one. But for me, from an issuer point of view, I have to issue together. I can't issue in isolation. If it is warrants, that's a beauty of this QIP in terms of the eligible securities. Just go ahead. Is there anything else left? I'll just... No, this we covered, all these things we covered. AB ho gaya. A placement document, I just told you in a simple terms about placement. Contents, I think you are covered nicely. Again, the price, in terms of the price, unlike you have 90 and trading days, it is only 2 weeks. Again, here the board can decide the date on which the board decide. You need to calculate 2 weeks prior to that. But here, Sudhakar, very interestingly, the determination of price is also being delegated to committee of directors if you want. So most of the companies, that's what they do in terms of the pricing, because many QIP, they want to launch it, but depending on the market condition, they slightly differ by a week or 10 days. That's why this flexibility is given to a committee of directors. So that is also possible in this case. And adjustment to the price, whenever you do a, any convertible, it will always, you need to adjust to this. Again, this also takes into effect the market volatility of the Regulation 3011, which has come recently. That also being, has been incorporated in this. Okay. Next, kuch hai? Convertible here, very interestingly, Sudhakar, in a convertible house, 18 months, but here it is 60 months.
60 months.
60 months. biggest thing that has come is the 60 months convertibility clause in this. So I think many companies have come out with listed entities, but unfortunately, what happens is these law firms and other people, they take away this entire chunk, but the entire groundwork, 95% of the work is done by the CS team. So friends, again, is there anything else, Khadija? I don't. Allotment, QABs, again, there is a restriction if it is less than 200, 250 crores, at least 2 allottees. If it is more than that, at least 5 people should be there. And always, if you see a QAB, even in an IPO, there is an importance that is given to mutual funds. Why? Because during those days, till 2016, I think 14 or 15, that mutual funds were also not getting that kind of a weightage in this QAB allotment or allocation. And hence, this change has come where mutual funds have to be given that kind of importance, and they will have to subscribe in all these things. Go ahead. वो तो बोल दिया आपने, इधर लिख दिया. At least AB हो गया. LODR regulations is in the form of regulation 29, regulation.
These are all disclosures and other things. Anyway, people know that.
So let me conclude, Sudhakar, saying that, friends, though preferential allotment and all these things looks like thing, but please don't take it for granted. Read several times before you launch into that. And we are capable and we are the best guys to do this. And irrespective of whoever is facilitating you in this journey, but you do your own homework and you will see the confidence level that you and I will carry, friends. I think the more we try to do, on our own, the confidence level builds up. That is what I wanted to say. Thanks for this wonderful Khadija, Bala sir and Sudhakar, and of course to Deepthi and Atul Bhai for organizing. Yes, can a company issue NCD along with warrant? The answer is yes. In a QIP, you can do this, friends. Somebody has asked, can private limited company issue convertible note on? Last time we pucha tha, convertible note and all. Ultimately, whatever wordings you you use, it has to follow in equity or convertibles, right? You just see that and follow the regulations.
Khadija,
somebody has acknowledged.
Khadija, you can stop sharing the screen.
Yes, sir.
Yeah. Okay. I think that is what. Thanks, friends, for attending last time and this time also. From 215, it has come to 165. I thought they would be waiting for lunch. I think wo bhi nahi mil raha hai karke from 183 it has come to 165 now. So
Raghunath, normally any webinar, if you actually see, the starting is actually good, the end it's slowly coming down and reducing. But still, if you look at the number at this time, it's a very good number because it shows very clearly what is the importance of the topic. That is why so many people are there. And another thing is there, you made my job very easy because you have been taking the question then and there only you have been answering it. So all the questions which have been raised in the chat box, many special thanks to you to make my life easier actually. That is one thing.
In fact, Ranga, what we have seen today was you started the presentation like a 5-day match. After that, in the between, we came that you played like a 50-over match. And in the last overs, it is a 20-20.
Because fifth day mein thoda karna padega na, sir, if you have to win.
Yeah, you are right. Absolutely. See that, Khadija, I'm sorry. In fact, last overs, I was to request Ranga to take over from you. But I'm sure that like a company secretary, you have abundant knowledge which you have put in your presentation. But what you need to develop the ability is the way Ranga has articulated it. And within no time, he could explain entire thing. That please develop that, which will come over a period of time. We're very young now, but for your age, what you have done is commendable. But what I request you is please watch this webinar again and again because you are the one who has presented here, the actual presentation you made it. But learn what Ranga could do that, which you have to do it over a period of time.
Sure, sir.
This comes with experience.
Yeah, comes with experience. Yeah.
See, because what happens is people nowadays, they're very impatient. Sometimes it happens that when we start that point of time, we start slowly and all because that warming up itself will take some time. But last hours, you should be able to express whatever you want to able to. And you have to close it because you cannot have a third part also.
Because that's why in between just to, some kahanis also that E-Lab whatever the PNB housing finance. These are all very important from
Yeah, very, very important. Yes. To understand the subject, you cannot just simply give that what's called a theoretical part only. You need to have the practical experience. I mean, experience as well as other what's called as the case laws or anything what had happened. We have to give the reference. But great, sure, Ranga, that I'm sure that the people who told me last week they're having a lot of expectations from you, and I'm sure that that you have exceeded their expectations. So we will give you the reward of A plus rating we are giving you. No increments at all. No increments, no promotions, but we can give you A plus rating.
At least a pat on the back, Sudhakar. That's all.
No, Raghunathan, it's a great sharing of your experiences. Many things what you have brought out really, really highly enlightening. Actually, the many things even I personally I came to know today. All those things, very great things, Raghunathan, you have been doing.
Because that's why I was wondering last time PPT ke sath kaise banna. I think Khatija was has a patience level to just to hang on with me to actually to say some certain things to explain and other things. First time I did Khatija this way. Otherwise PPT piche my flow will be there. That's how normally I do. But never mind. Good. You took wonderful efforts to do this because QIP I did not know whether she had made last time. Naita, I called up Disha. She said it's already covered. And so, well done, Khatija, and everybody.
She has definitely done the excellent homework and preparing the things and putting the things very nicely. My special appreciation to her that putting the things. That is very clear.
Thanks to all the friends, all the professional friends for coming and joining, and whatever we could sort out, we could reply to so many things. But anything in particular, friends, if you really want, don't pose any hypothetical questions. Maybe you can just approach us, and we are there to just to initially, without free of cost, Sudhakar, as you said, complimentary. Then because wo sab baad mein karenge. But just for the sake of understanding, giving a clarity, always please, we are approachable, and you can always comment.
See, let me tell you, Ranga, that when I was in service, that point of time, everything was complimentary. But when you have opened your shop,
I think Nikhil Patel
will say by everything, if you are giving complimentary, then what we have to do it then?
I think Nikhil Patel has raised the hand. Are you there, Nikhil? You want to say something? Nikhil Patel?
Acha. You would have gone, sir. Lunch किधर दे रहे हैं आप, बाला sir?
आप जिधर बोलेंगे उधर देंगे.
So somebody has written very nicely. I think, I don't know. Learning is important, sir. Then lunch. Great session. Very nice. Well put. Thanks a lot. Thanks a lot.
Thank you.
So good, Sudhakar. We will meet. We'll again catch up.
Sure, sir. Definitely. Thanks very much once again on my personal behalf as well as on behalf of Mehta and Mehta for accepting our invite and spending your time for 2 webinars of that means 4 hours each. And I'm sure that a very interesting topic again in the near future we will be in touch with you. Thank you very much. God bless.
Thank you, Raghunathan sir, and thank you, Sudhakar sir, for giving the opportunity to be the presenter of this topic. Thank you so much.
Thank you very much to all. Have a good weekend. We have to meet in the next session. Enjoy your trip to Babalishwar, Sudhakar.
Thank you, sir. Thank you very much.
Thank you. Thank you very much.
Thank you.
Thanks.
Thanks to you.
Yeah, thank you.
Yeah, we close the session with this. Thank you.